One thing that I have done consistently in my practice, actually going back to before my practice, when I worked at the USPTO as an examiner, is working with office actions. An office action is when an examiner at the USPTO issues a letter to the applicant asking for more information or notifying them of a procedural issue or notifying them of a substantive issue. And now in private practice, every day, pretty much every week, I am working on drafting office action responses. And this is something that I've actually spent a lot of time thinking about over the years because I've spent so much time working on them that I've actually taught a course about them. And I've worked hard to focus on the core elements of a strong or effective office action response. And I want to share with you briefly today about the 4 key elements of a strong response. The first is finding compelling evidence. When you're building a substantive response, whether it's a likelihood of confusion issue or a descriptive issue or some other issue, attaching compelling, usable evidence that's tangible to the response, I think, makes a significant difference. It goes a long way towards enhancing and building the argument. Of course, the second element is that, of course, knowing the relevant cases and law that apply to the issue are going to help incorporate and build your argument significantly, and they're important to know and they're important to reference in the response. The third element of an effective response is knowing the USPTO's procedures. Their procedures are very particular, they're very complex. There are issues that come up now, even after I've been doing this for 20 years, over thousands and thousands of responses. There are new issues that come up where I've never seen the exact procedural situation. But even the core basic procedural issues are important to know for every response. How to format it, how much time you have to respond, those kind of things. And then finally, the fourth element of a strong response is tying it all together with persuasive writing. And I work a lot on this when I'm teaching law students or when I'm teaching other lawyers in finding the right voice, the right mix of professional legal writing, but not so overly formal that the substance and the persuasion that you're trying to incorporate gets lost in the formality. So I think an effective writing style for an office action response is not quite as formal as a legal brief or a legal memo. It's more like a business memo or a business document with evidence and case law included into it. So there's a visual that goes along with this. I'll put it in the links and more information there. I encourage you to take a look at it. If you incorporate these 4 elements into an office action response, that is what I believe will give the best chance of convincing the examining attorney to take your position and perhaps withdraw a refusal.
That's not true.
If you have questions about office action responses, you can reach out to me on email, on social media, in the comments here, or on my website at ericpelton.com.